Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this webinar on risk assessments and the application of organizational controls for GDPR compliance. I'm Alan Calder. I'm going to be your host this afternoon. We're going to be together for about an hour. My background is not in either law or technology. My business background goes back to the first certification to the international standard, what is now ISO 27001 for information security, and the business that I've developed over the last 15 years is now an international operation which spans publishing, training, consultancy, and we deliver services in the full range of governance, risk management, and compliance areas dealing with cyber resilience, information security, business continuity, PCI compliance, business incident response management, and very significantly since the passing of the General Data Protection Regulation just over 14 or 15 months ago in GDPR. Broad range of services, as I said, cyber resilience, and of course IT service management, the other side of security. And in the hour or so that we are together today, I'm going to be talking about very briefly, for those of you for whom this might be new, and for those of you who are, for whom it's not, to set in context, an overview of GDPR and how risk assessments fit into the requirements of GDPR, what a risk assessment looks like, the process for risk management and best practice for risk treatment, what an internal control system components might be in respect of risk, and the internal and the privacy compliance framework. And we'll touch on ISO 31000 and ISO 27005 as risk management methodologies, all, as I said, in the context of GDPR. I'm going to be talking for about 45 or 50 minutes. At the end of that, there'll be an opportunity to ask questions, but please don't feel you have to wait until then. The question entry section of GoToWebinar, which should be on the right-hand side of your screen. If you go into it, you can type questions into the question box, type them as and when you think you have a question, and I'll make sure that when we come to the Q&A, but what I'll do is I'll then turn to the questions and I will read them out in the order they've been posed, and then I'll give you the answer to the question, and we'll get through as many of the questions as you've got. So as I said, don't wait until the end. Do, as soon as you have a question, put it into the question section of the GoToWebinar control panel. And the first question you ask is, will these slides be available? Yes, the slides and a recording will be available typically sometime in the early part of next week to everybody who's registered for this webinar. So let's get to it. The GDPR, as you know, comes into force on the 25th of May 2018. That means there's not a lot of time left to get compliance, something like around 7 months or so, slightly less than 7 months. The 25th of May 2018 is the date by when you need to be compliant, not the date after which you need to be compliant. And the importance of that is that we are about 15 months through the transition period that the lawmakers allowed. So there's just slightly less than 7 months to make sure that you are, by the 25th of May, processing data in compliance with GDPR, that you've taken the appropriate steps, having identified risks to that data and put in place controls that will protect that data. So not a lot of time. The regulation extends the rights of individuals quite significantly. You read in places this is just a minor extension of the Data Protection Directive. In reality, it's quite a significant extension of it. It's a significant extension of the body of law because in a number of areas, GDPR is very specific about what is required of controllers and processors, but is also an extension of uncertainty because there are a number of phrases and terms in GDPR which are not defined, and we'll be talking about some of those terms in the course of today's webinar. The first undefined terms is appropriate technical and organizational measures. The requirement is that organizations have to adopt appropriate technical and organizational measures to protect the rights and freedoms of data subjects whose data they are processing. It's applicable across the whole of the European Union in all member states. It's applicable in the United Kingdom from the same date as everywhere else in the European Union, and the UK government is in the process of making sure that there's no uncertainty beyond Brexit as to whether or not GDPR applies, because the UK's data protection bill currently before Parliament puts GDPR firmly into UK law, onto the UK statute book, and ensures that it will survive beyond March 2019, when Britain in theory leaves the European Union. The other thing which occurs in the UK bill is the taking advantage of those derogations which GDPR allows member states to take advantage of, but otherwise the UK data protection bill is simply the General Data Protection Regulation being put onto UK statute books, not being left to apply simply by virtue of being EU law. The material and territorial scope, again, a reminder for those of you who've been following these webinars, the natural persons, anybody about whom a controller is processing data, has the right to their personal data being protected, to the processing of that data being protected, and the unrestricted movement of their data within the European Union. Within scope of GDPR is any personal data processed wholly or partly by automated means, and any personal data that's part of a filing system. It applies to data on paper just as much as it does data in digital format. It applies to voice. Any form of data that you care to identify is covered by GDPR. It also applies to controllers and processors outside the European Union in just the same way as it applies to controllers and processors inside the European Union. If you're a controller or processor providing services into the EU from outside it, you too must comply with GDPR. And there are a number of specific provisions around those types of entities. So it's if you like, the first global general data protection regulation, and it has a significant impact, therefore, across the world. And it has a significant impact because for the first time there are very substantial fines attached to breaches. Fines for lower level breaches go up to 10 million euros or 2% of global turnover, whichever is the higher. And for the major breaches, which is breaches in relation to the data processing principles, the 6 of them, the 8 data subject rights, and the transport and data processing, breaches in those areas can attract fines up to 20 million euros or 4% of global turnover. In every instance, fines have to be proportionate and dissuasive. Dissuasive, we think, means they have to hurt, but they also have to be proportionate to the transgression and to the size of the organization that transgresses. So a 1 million turnover business couldn't possibly be fined 20 million euros. That would be completely disproportionate. And the fines are difficult to avoid because you have to report data breaches to the supervisory authority. You've got 72 hours as a data controller to do that. And data subjects have the right to bring complaints if they think their data is being wrongly or unlawfully processed, bring a complaint to the supervisory authority, or indeed to bring an action in a court of law where you are or where they live as they prefer, and to seek financial compensation even for non-financial damages. So the possibility of individual action, and individual action has the possibility of leading to supervisory authority action, as they say, gosh, you've had a number of law cases against you, you must be doing something wrong, particularly if the findings are against you, can lead to an investigation, can lead to a discovery that actually you're not complying with GDPR, and therefore along come a set of fines. So the fines, in other words, don't come just because you have a breach or just because there is a data subject action against against you, it can be triggered by an information commission or other supervisory authority investigation, and they have powers to investigate sectors, companies, as they see fit as part of their general responsibility to enforce the regulation. So risk management, Article 32 says that controllers and processors, and those are both terms which are defined within GDPR, have to implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. Said appropriate isn't defined, level isn't defined, it's something you, the organization, have to do. And the guidance which GDPR gives you is that in assessing the appropriate level of security, you have to take account of the risks that are presented by the processing, and this is risks to the data subject, not to you, the organization. The risks that arise to the data subject from unlawful or accidental destruction, loss, alteration, or other damage to the data, unauthorized disclosure of or unauthorized access to that data. You have to assess that, and you can't just do it on a subjective basis. You decide that it's quite risky or not risky, because that's not going to stand up as an appropriate set of steps to deal with a significant level of risks. What you have to do is, taking into account the nature, scope, context, and purposes of processing, as well as risks of varying likelihood and severity, implement appropriate controls and be able to demonstrate the processing is performed in accordance with this regulation, and therefore in accordance with the requirements to do this. The data protection officer has got a key bridging role to play between how the organization handles corporate risk and the broader cybersecurity risk management, and the very much more specific risks to the rights and freedoms of data subjects which have to be managed. For those of you who are in the critical national infrastructure sector or providing information society services, platform-related services, the Network and Information Security Directive has similar requirements around protection and reporting of breaches. It also comes into effect in May next year, so you want to be thinking about how you combine both of those elements in your compliance strategy. So risk assessments under GDPR, and as you begin thinking about risk assessments, you see that in Article 35, the regulation says that when you're planning to use new technologies or, for instance, perhaps making changes to how you're processing data, you need to take account of the nature, scope, context, and purpose of processing, recognizing where it's likely to result in a high risk to the rights and freedoms of natural persons. What that means, really, you take clauses, Articles 32 and 35 together, is you need a formal approach to risk assessment and risk management. You need some formal definitions of words like likelihood and severity. You need a mechanism for defining the difference between low, medium, and high risk. And you need to be able to link those decisions to the controls that you select. In a number of instances, those decisions about risk management may form part of how you do what's called a data protection impact assessment. A data protection impact assessment is mandatory where, as an organization, you're doing automated processing or profiling, which will lead to automated decisions about people, where there's large-scale processing of special categories of data or of data relating to criminal convictions, or where you're systematically monitoring a publicly accessible area on a large scale. In those areas, you have to do a data protection impact assessment, and a DPIA is simply a series of activities which set out what processing is that you're doing, what the legitimate interests are of the processing, an assessment of the necessity and proportionality of the processing, an assessment of the risks to rights and freedoms of the data subjects, and then the selection of measures that you put in place to address the risks. So a data protection impact assessment is just like the assessment of risks generally to data subjects, very dependent on you having a formal and effective risk assessment methodology. Let's start with the definition of risks. Definition of risk. ISO 31000, which is the international standard for risk management. It's widely used. It provides guidance at a corporate level on how to put together a risk assessment and risk management strategy. Defines risk as the effect of uncertainty on objectives. The effect of uncertainty on objectives. In other words, the business has a number of objectives. There are a number of things which might occur or transpire which might knock you off course, and those things ISO 31000 says are risks. It also makes it simpler. It says you might think about risks as being a combination of the likelihood of something occurring and the impact if it does occur on the organization, or as GDPR puts it, a combination of likelihood and severity. So the GDPR definition of risk fits very closely to the ISO 31000 definition of risk. So what you're looking at, and putting aside the fact that risks can have upsides, you can have more sales than you were planning to do, which could be a good thing. Risks, primarily where data protection is concerned, we're looking at risks on the downside. We're looking at the probability or the threat of damage, loss, or any other negative occurrence caused by external threats, internal vulnerabilities, and that could be avoided through preemptive action. Key definitions then: risk management is the coordinated activities that an organization puts in place to direct and control an organization in relation to identified risks. Risk assessment is the overall process of identifying, analyzing, and evaluating risks. And risk treatment is the process that you go through to modify risks. So risk management obviously therefore includes assessment and treatment. And before you can treat, and treating is the selection of controls or other actions that you might take to deal with risk, you need to have gone through the process of identifying the risk, of evaluating its importance, and therefore putting yourself in a position to decide what to do about the risk. Now, when you're thinking about risk to the organization, that's relatively straightforward, because you're looking at what the impacts on the organization might be if X or Y actually happens. And you can look at that in terms of actions brought against the organization. You can look at it in terms of the consequences of loss of data on a contract with a customer. You can look at it in terms of reputation damage. They're all relatively straightforward in terms of looking at risks to organizations. What GDPR is asking you to do is not to look so much at risks to organizations, but to look at risks to the rights and freedoms of natural persons. That's what GDPR is all about. It's about protecting individual data subjects. And remember that data subjects can be working in businesses just as much as they can be consumers. There's no differentiation between B2B data or B2C data for the purposes of GDPR. So risks to the rights and freedoms of data subjects, you need to be thinking about how the actions you take in relation to data subjects might affect their risks. And your scale of risk might be different when looking at individuals than it is when you're looking at the organization itself. You should already have privacy risk on the corporate risk register. As part of your GDPR project, you should already have identified GDPR as a major compliance risk area, and risks to the rights and freedoms of data subjects should be sitting on your corporate risk register as something that you need to be addressing. And in addressing it, what you're going to be doing is trying to identify threats that could harm the data subject. You're trying to identify the value and sensitivity of the data which could be compromised, because that enables you to identify the harm to the individual. And then you're going to try and put in place measures that are appropriate to reduce the risk. There's nothing in GDPR that says you have to eliminate all risk to data. There is an acceptance implicit in GDPR that when a data subject gives to a controller their data, there are going to be some risks. Organizations are doing things with the data that is designed to produce a particular result for the data subject. There is nothing in GDPR which says you must eliminate risk. There is everything that says the risk must be appropriate, and the controls put in place must be appropriate to the risk, and the data subject must be aware of what's going on and be able to have control over their own data, because at the end of the day, it's them who are harmed when there is a breach. So the job of a risk assessment is to help the organization determine appropriate controls to bring exposure down to an acceptable level. So for risk to exist, you've got three issues that have to be dealt with. The first is an asset. And for the purposes of GDPR, the asset we're concerned about is the data of a given data subject or a set of data subjects. So you might have customers for a particular service. There might be 25,000 of them. That's the asset. It's their data, that 25,000 strong cohort, their data. You need to have a vulnerability. You need to have some weakness in the way that data is held, and you need to have a threat that's going to seek to take advantage of that vulnerability. So having, for instance, if you're thinking about paper records, unlocked drawers with paper records in them, a vulnerability would be the fact that the drawers are not locked. There is only a threat if somebody can get into the room who has no right to access the information. If you can determine that there is absolutely no threat, you might therefore determine that there is no need to lock the drawer. You need a threat and a vulnerability for there to be a risk. And that's an important first set of definition to build into your risk management methodology. There must be both threat and vulnerability, and where those two coexist, you can begin thinking about what the level of risk is. So, you're assessing a risk because you want to put in place a proper balance of safeguards. The safeguards at an ISO 31000 level are about how do we make sure that anything that might occur won't compromise our opportunity, compromise the likelihood of us achieving our business objectives. And we want to be able to make decisions about the controls we put in place, such that if we put in place more in the way of control than we need to, business will become unnecessarily bureaucratic. But if we release any control so that we're moving away from what our risk assessment says, then the exposure to the organization would be unacceptable. So risk assessment should enable you to make decisions about the appropriate level of control, which take into account the cost of the control and balance the cost of the control against the likely exposure of the data subject's assets. So risk assessment is a means by which expenditure on security can be justified because you can relate it very specifically to the impact on the organization if the threat exploits the vulnerability. So what types of risk are we thinking about when we're looking at GDPR at personal data? If you think about, for instance, data that's inaccurate, insufficient, or out of date, that's a typical risk, and it's a typical risk because it means that somebody's information might be sent to an address where they're no longer living, which means it will be made available to people who don't have the right to see it. Or if you've got the wrong address for somebody, you won't be able to send them the information they need as and when they need it. If data is inadequate, you might not be able to judge whether somebody has an entitlement to a particular insurance payout or some other benefit. So keeping data accurate, up to date, and in line with the purposes which it's originally collected is a requirement of GDPR. It's a risk if it falls out of date. If you've kept it for too long, you've kept it beyond the purpose for which it was collected, you expose the data subject needlessly to risk because, of course, any data that you held might be accessed by an attacker, and the release of data, however old, can compromise people. The fact that somebody gave you their data 15 years ago when they bought something from you, they haven't done any business with you since, but they haven't moved their data, still the same. If you then have a compromise and their data is released onto the dark web, then it means that somebody can use their data to carry out fraud, and it will have an impact on the data subject. If the purpose of collecting the data 15 years ago was for a single transaction, then the processing of that data, in other words, including the storage of it, should have ceased at the point when you no longer had a statutory obligation to keep records of that transaction. So keeping data for too long is a risk in GDPR terms. Collecting data that's excessive or irrelevant to the purpose is another risk in GDPR terms, because if you're collecting data you don't need to have, it means that there is data on your systems that an attacker could get access to, and which could therefore be used to compromise the data subject. So excessive or irrelevant data is an exposure. Data disclosed to the wrong people because, for instance, you have a vulnerability in your system for determining access rights, means that members of staff might have access to privileged information about high net worth individuals who are customers of yours that they shouldn't have access to. And that means that your customers' data is compromised, their right to privacy is affected. It might mean that somebody decides to attack them separately or at home because it's now known that they have a significant level of wealth. Data that's insecurely transmitted or stored is another risk. If data is sent not encrypted, it's possible for somebody to sit in the middle of that email chain, collect the data, look at the information, and do things with it. It's not unusual that, for instance, in a housing transaction where the transmission of funds between lawyer and the seller of a house takes place, that somebody, an attacker is able to infiltrate that email chain, pose as the seller, and to give the solicitor a different bank account details so that the money is sent to somebody else's bank account. Of course, those bank accounts get emptied almost immediately, but it doesn't change the obligation of the lawyer to send the money to the seller. It gets to be a very nasty and sticky thing. This happens a lot. There's an article in one of the UK's leading newspapers today about a number of art galleries which went out of business through a similar fraud. Attackers were able to infiltrate email chains. When art was sold on at auction, the payment from the buyer went to the gallery. The gallery then forwarded to the seller, but the attacker was able to infiltrate the email chain, divert the money to their own account, make off with the money. Didn't mean that the gallery's obligation was extinguished, and the galleries went into, some 2 or 3 of them were forced to go into liquidation to close down because they weren't able to meet their obligations. So these kinds of exposures, data not being encrypted in transmission or in storage, is a major security risk. Data being used in ways that are unexpected or unacceptable is another privacy risk. The fact that you collected data from data subjects in order to provide them information about, let us say, fridges, doesn't entitle you to suddenly start selling them holidays at a special price. That kind of approach is likely to upset data subjects. When data subjects are upset, from a legal point of view, it's likely that you transgressed their rights. So it's a risk that if access to data isn't properly controlled, you're going to have a data subject impact that can lead to the data subject taking action against you. So those are some examples of risks that arise in relation to data. ISO 31000 says, okay, you know there are some risks. Here's a way that you can systematically go about identifying what the risks are and making appropriate decisions that anybody else can audit, can follow, and in your absence can apply to arrive at similar decisions themselves. So the starting point would be to identify risks. You'd identify the assets at risk. So from a data protection point of view, you'd be identifying what categories or types of data are at risk, where it's held in which inventories. You'd be looking at the threat vulnerabilities, relationships that there are in relation to those assets. So you'd look at data in a database. You'd say this is HR data. It's quite a wide range of data, might include health data, for instance. And you'd be looking at threat vulnerability relationships. You'd be looking at the fact the database is not encrypted. You'd be looking at the fact that anybody in the organization who has access to the databases could also access that database. Or you might say, well, we've got role-based access, but the IT team can still access that database because they've got system administrator rights. You've got a threat and you've got a vulnerability, and you have to work out how significant that is, and you therefore have to analyze the risks. You have to say to yourself, what's the likelihood of somebody taking advantage of the fact that they've got access to the HR database to actually go and look in the HR database? What's the likelihood? And if they do, what's the consequence to the organization? If they happen to see a whole set of information about people which might lead them to further a personal harassment action against somebody, to harass somebody further, cyberbullying, all of those kind of things could come out of somebody getting unauthorized access to an HR database. You'll look at consequence and probability, or impact and likelihood. And typically what ISO 31000 would say is, if you create a risk scale, if you were to say have an X graph, X, Y graph, where you take likelihood and impacts and put one on each of the axes, you can then apply a set of levels like low, medium, and high to the level of impact, and low, medium, and high to the likelihood. And you can, where there's an intersection between those two things, say that's where the risk is. And I'll give you an example of that shortly. So ISO 31000 says, when doing a risk assessment, think about the nature and types of causes of the threats, look at the consequences that might occur if those threats materialize, work out how you'll measure the consequences. Are you going to measure in terms of length of exposure or potential damage to the data subject? Work out how you're going to determine likelihood. What are the criteria that you're going to apply? And likelihood should be something which is based in reality, not in myth. So you shouldn't be saying, well, there's a possibility that on our trading estate, somebody might come in at 7 o'clock in the morning and open the buildings and be working in one of the buildings alone, and then somebody else might come along at 7:05 and attack them and steal all the computers. Yeah, it's invisible. The key thing you'd want to do is get data about how often buildings are opened at 7 o'clock and how often there are unauthorized intruders at 7 o'clock. That would give you the opportunity perhaps to determine that the likelihood of that event occurring is low, even though the impact is high. You take both of those into account in considering what you do about the possible risk. What's the time frame over which the likelihood will wind itself out? So how does a minor attack today look like when it's been escalated into a major denial of service attack tomorrow? How is the level of risk to be determined? Are you going to determine it in terms of the impact on the data subject, simply in terms of recovering their data? Are you going to determine it in taking account of the possibility of identity theft? What are you going to take into account in determining the level of risks? Do talk to stakeholders, says the regulation. Talk to data subjects, or if there are a lot of data subjects, talk to their representatives to try and make sure you're properly assessing what they see as being the level of risk. You've then got to define what is acceptable in terms of risk. Remember, GDPR isn't expecting you to eliminate all risk. It's simply expecting you to put appropriate controls in place to manage risk. And there is some risk. GDPR does not require the reporting of risk where there is little or no danger, little or no risk to the rights and freedoms of data subjects. Make your definitions of what no risk is. That's your definition of an acceptable level of risk. Make a decision as to what medium and high risk looks like, bearing in mind that high risk breaches have to be reported to the data subjects themselves. You can also do a risk assessment on a scenario basis, and there are typically either scenarios or asset-based risk assessment. A scenario-based risk assessment would be looking at, for a given set of personal data, who the actors, the threat actors might be. Are they internal staff or contractors? Are they competitors or hackers or partners? Who the threat actor might be, what the threat type is, which could be malicious software, malware, could be error by somebody internally, could be failure of a system, could be a natural disaster, some external complication. So what's the threat type? And the combination of threat actor and threat type enables you to begin thinking about what type of events might occur. So the logic is, yes, malware exists, but without someone aiming malware at your system, it's unlikely to be something to worry about. So that's why you want to look at who the threat actor is. Threat actor, threat type, that leads to the events. And the event itself might be the theft of data or the modification of data. It might be unauthorized disclosure or interruption of processing. It might be ineffective execution of a process or a service because the data in it is incorrect. All of those are the types of events which might manifest the fact that a particular threat has been to work. You know what the asset is. Remember that GDPR requires not just the protection of personal data, but also the protection of the systems within which this data is being processed. And therefore, from a GDPR point of view, you need to be thinking about premises, you need to think about IT systems, people, organizations, infrastructure, applications, operating systems, and everything. They're all part of the processing of personal data. And of course, you need to look at time. You look at the duration of an attack, the duration of events, the timing of it when it occurs. There's a reason, for instance, why most data breaches occur on a Friday afternoon when the IT team has gone home or gone to have a hard-earned beer. It's because that gives the attacker the whole of the weekend to get on with doing whatever they're doing, and you only find the breach on a Monday. So when are you going to detect it? How do you make sure you've detected it? How do you deploy a mechanism to contain the breach? Are all part of thinking about the risk scenario. So ISO 31000 we've looked at, a risk-based scenario we've looked at, and ISO 27005, which is the international standard in the ISO 27000 family for risk assessment, risk management and risk assessment, has a very specific set of standards. It's designed obviously to work with ISO 27001, but you can use ISO 31000, you can use that risk-based or that scenario-based methodology as is appropriate for the organization. 27005 says establish the context within which you're doing the risk assessment, identify the risks. That's a matter of working out what is happening, analyze them, look for likelihood and impact, evaluate them by comparing risks to find out which one is less or more serious than the others, and then make decisions about how you're going to treat the risk. And treatment comes into really only four options. You can treat a risk by avoiding it, so you don't do the thing which gives rise to the risk. You can treat a risk by accepting it. That means, again, you're not going to do anything. You're just going to live with the fact something might go wrong. You can treat a risk by transferring it to a third party, typically through insurance. Outsourcing activity doesn't necessarily transfer risk. Insurance transfers the impact because it means somebody else gives you money if the risk occurs. And the final thing you can do is select controls to reduce likelihood and or impact. So if you think of risk on this kind of XY graph with likelihood on one axis and negative impact on the other, and you plot a risk as being, let us say, very high because it's got a high likelihood and a high impact, it falls into the top right corner. It's a very high risk. And if you've determined that an acceptable level of risk is anything which has got a low or very low risk assessment, you're then going to be seeking to select and apply controls to bring the risk down from very high to the borderline between what's acceptable and what's unacceptable. You don't want to bring risk down to zero because remember, there's no point in spending more money than you need to. You make a definition of what an acceptable level of risk is, and then you invest money to bring the identified risk down to that acceptable level. And you bring it down by selecting controls. ISO 27001 has in Annex A, ISO 27001 is the International Information Security Management System standard. It has a list of some 114 controls arranged in some 14 control categories. Those 114 controls are explained in much greater detail in ISO 27002. The Annex A is simply a list of controls. And what you should be doing is selecting those controls in terms of the objective you're trying to achieve. What is it you're trying to do in terms of reducing that risk? There will be steps that you're trying to take account of organizational objectives, of operational constraints. Your control might reflect the fact that you can't afford to invest substantially in technology, but you can make a control work by training people and by auditing it. All of those kinds of controls are included in the ISO 27001 list. When selecting a control, you're perfectly entitled to take account of the cost of designing, deploying, and operating the control in relation to the risk. If the risk is very low, there is absolutely no need to spend a very high amount of money on reducing the risk even further. Frankly, if the risk is very low, you might decide that you're simply going to accept the risk and invest your money in tackling what are quite clearly high levels of risk to bring them down to a more acceptable level. Remember, therefore, that risk assessment is the method you use to balance investment in controls against the harm that an organization might suffer if there is a breach. And so a sensible way to think of GDPR compliance is a set of controls designed to protect the organization from a breach. How much should you spend? A starting point for thinking about is saying, well, the top level fine is 17 million pounds, 20 million euros, or 4% of global turnover if you're somewhat bigger than that. And that maybe should set a ceiling for the amount of money that GDPR compliance is worth investing. Why do I say a ceiling? Because if you have 2 or 3 breaches over the course of a year, each one of those could trigger significant fines, and you still have to go and comply even after you've paid the fine. So there is a certain elegance in the idea of complying before you pay fines. Countermeasures are typically going to be in the people, process, or technology arenas. You're going to usually, even if it's much more focused on people or process, for something to work, you're going to need a process to ensure that people are properly trained. If you're deploying a firewall, you're going to need to make sure that you've got a process that defines what an adequate level of security on the firewall is and how the firewall should be set. You need people trained to operate. And so typically, while many controls look as though they're primarily people, process, or technology, the reality is that good control frameworks depend on each one of those 3 elements. Think of them as being like the 3 legs of a stool. Each one of those elements needs to be there and working effectively with the others to give you effective control. So the kinds of risk treatment that an organization might deploy to deal with some of the risks that we've identified might be, for instance, reduce the amount of data you've collected. If one of the risks is that you've got excessive or irrelevant data, you could simply reduce the amount of data that you collect. So not all controls that you put in place automatically involve firewalls or anti-malware software. Many of the controls can simply be process-oriented controls that ensure that you're complying with GDPR, because what you're trying to do is not just protect from outside attack, you're trying to protect the rights and freedoms of data subjects. You might have a retention policy. A retention policy is also a good way of ensuring that data which you've collected is not held for longer than it should be. Putting together a retention policy is complex because not only is there one element of determination based on the purpose of processing, but there are many statutory and other legal obligations that set out how long particular types of data should be kept. And your retention policy should identify all of those and should ensure that the data you're collecting is retained only as long as it says it should be. Secure destruction of information once you reach the end of the retention period is obviously a sensible thing to be doing, but when you're destroying information, it needs to be done securely, particularly paper information or digital information on hard drives. You want to make sure hard drives are shredded. You want to make sure documents are shredded. You don't want to simply hand over boxes and boxes of data to somebody without knowing for sure that they take them away and shred them securely. Access control is obviously a key risk treatment. It's a way of making sure that only people who need to have access to personal data actually do have access to personal data, and you can usually do this some form of role-based access control. Staff training and awareness, the pseudonymization of information, which is breaking information up into 3 or more individual elements, none of which enables a person to be identified, but which when reassembled enables you to identify somebody, is a perfectly legitimate method of risk treatment, as is encryption. Putting in place contracts with processors, making sure if you're a processor you've got a proper contract with a controller is another good risk treatment or risk mitigation measure. It's a way of making sure that your controllers know what they have to do. Sorry, your processors know what they have to do. They know how to report a data breach and so on. An acceptable use policy would set out for staff, for third parties, what an acceptable use of assets might be, and that would include how those assets can be used to access personal data. Subject access request process is a control that you put in place to ensure that data subjects are actually able to exercise their rights. There's a risk to data subjects that arises from you not doing that. External supplier risk assessments. There are a number of different risk treatments that you can deploy. They don't all necessarily mean the deployment of technology. They're driven, though, by the understanding of what the lawful basis of processing, the purpose of collecting and processing the data is, and making sure that that understanding drives all the way through the thinking about the risks to rights and freedoms of data subjects. So you can think about this standing back from it in a cost and risk level. Typically, the more controls you put in place, the greater the number of vulnerabilities you will have eliminated. So what that means is, as you see on that, the number of vulnerabilities goes down. At the same time, your cost goes up because the more and more controls you put in place, the higher your level of investment will be. So the challenge for you as an organization is to determine what level of risk is acceptable. How far do you want to see vulnerabilities reduced? And we're talking about vulnerabilities that lead to exposures of the data of the people whose data you're collecting, and how does that balance against the cost of collection? You might, as this diagram indicates, choose from an organizational perspective to put that graph quite far to the left. You might say we're prepared to take quite a lot of risk because we want to keep our costs down. And that might be a perfectly sensible thing to do from an organizational point of view because your risk appetite might be quite high. What you have to do is think about the risk appetite of data subjects because it's their data that's exposed. That might lead you to recognize that actually in respect of data subjects, your risk acceptance criteria might need to be much further to the right, certainly somewhere round about the intersection of those two lines and perhaps further over to the right. And part of the reason why in a data protection impact assessment, GDPR encourages you to talk to stakeholders is because it enables you to identify what their acceptance of risk might look like. So proper balance between the costs and benefits is what you should get out of a risk assessment. You should move away from a knee-jerk situation that says all risk is bad, get rid of all risk, into an area where you're making practical, objective decisions about the appropriate amount of money to invest in organizational and technical controls to reduce risk to the rights and freedoms of natural persons. So a practical approach, agree the approach to risk management. How are we going to do it? Get together with the compliance people, get together with the owners of risk management inside the organization and determine how you're going to take the risk management approach that the organization already use and adapt it to the requirements of GDPR. What level of assurance does management and do other stakeholders require that risk is managed down to the level that has been determined as acceptable? Then do the risk assessment. Make sure that those doing it understand the methodology, make sure they get properly trained. What you're trying to do is ensure that the risk assessment produces comparable and reproducible results. Anybody else should be able to come along, apply the same methodology and arrive at the same decisions about how to treat the risk and what controls to put in place where treatment is going to be about controlling the risk. And you then put in place the controls that will enable you to manage that risk down to an acceptable level. So step one, assess and identify, assess the risk, identify it, make sure you've prioritized the initiatives that you need to be taking to deal with risk. Look at the data that you're trying to protect, classify the data, make sure you're clear about where you're holding personal data, the data of minors, and special categories of data, specifically sensitive information, special categories of data. You need to recognize that there are greater attractions, and therefore when you look at threat actors, more likely to go for more valuable information than less valuable information. Classify data, take action to deploy the controls that you've selected to reduce likelihood and to reduce impact, and at the same time implement an incident management plan. Recognize that however good your controls are, you're still going to have security breaches. They will be whether from an accidental deletion of a file all the way through to a major attack by a cyber criminal. You need to be able to recognize them and have a mechanism for responding to them, which you don't have to work out at the same time as trying to respond. So a properly prepared and tested incident management response, which should include determining how to report a data breach to the supervisory authority. But that's not the end. GDPR, as I'm sure you will hear many times, is not a destination, it's a journey. You get to the May next year, you're not finished. That's simply the date by when you need to be able to demonstrate compliance. The reality is that embedding data protection by design and by default in all of the organizational systems is going to take another year or two. And once you've got it embedded, it then becomes part of your everyday processing and business activities. And part of making sure that works is that top management has to ensure that there's ongoing risk and incident monitoring, ongoing monitoring of compliance with GDPR, ongoing internal audits. A very specific requirement of GDPR that there's ongoing audits and monitoring. So that's a practical approach to risk management for GDPR compliance. One of our subsidiaries, Vigilance Software, produces a software tool which is designed to make risk assessment pretty straightforward. It reduces and removes a whole lot of the repetitive stuff, removes many of the issues that come with creating your own risk assessment methodology in a spreadsheet. And the key thing with the risk assessment methodology is you want to be able to revisit it, you want to be able to assess changes, you want to be able to add assets, you want to be able to recognize where risks have changed, and that leads to changes in your controls. So a risk assessment tool like VS Risk, and you can read about it on the Vigilance Software website, it's sold through IT governance websites as well, will minimize the manual work, it will enable risk assessments to be replicated easily in a standard format. It will generate all of the reports that you might need from a business management point of view, as well as from an audit point of view. And of course, it's automated, so significant elements of the work happen and take place quickly and easily. As an organization, there's a substantial range of self-help materials, pocket guides, manuals, compliance gap assessments, documentation toolkits, internationally certified training courses, and a wide range of consultancy services which you can draw on to help you with your GDPR compliance journey. And that, ladies and gentlemen, brings me to the end of what I'd planned to say. In the time we have left, I'm going to address questions. As I said at the beginning, if you have questions, please do type them into the question box on GoToWebinar. What I'm going to do is I'm going to go through each of the questions as they are. I'm going to read them out, and then I'm going to tell you what I see as being the answer to the question, and I'll get through as many of them as I can in the 10 or so minutes that is remaining. Legitimate interests is not, I'm afraid, really a subject of the webinar. It's defined in GDPR. Legitimate interest is something which an organization has got a legitimate reason for doing. If you start in Article 5 and then go and look at the recitals, you'll see a number of descriptions of what is legitimate. It is, for example, legitimate for an organization to track the activities of a member of staff on its network for the purposes of preventing cybercrime. That's a specifically identified legitimate interest in GDPR. Direct marketing is a legitimate interest. So if somebody phones up and says, I'm interested in fridges, it's a legitimate interest to send them information about fridges. You don't need to ask their consent. They've already told you that they're interested in fridges. It's a legitimate interest to send them other information about fridge-related products, but it's not a legitimate interest to send them information about holidays, as an example. GDPR applies to organizations based in the European Economic Region. It applies to organizations, A, who are based in the European Union, and it applies to organizations based outside the European Union, but which are providing services into the European Union. To what extent do I think Annex A of ISO 27000 and an information asset risk register will demonstrate compliance with GDPR? Only to the extent that you've built GDPR into your ISO 27001 management system is the practical answer. If in clauses 4.1 and 4.2 you've identified GDPR as being the context and the requirements of interested parties, you've identified amongst your assets the personal data, and you've gone through the business of selecting controls in order to reduce risk to the rights and freedoms of data subjects, then yes, ISO 27001 will do a very good job in helping you demonstrate that you've made appropriate steps to protect the data of data subjects. If someone's name is on a document, is this classed as personal data? Yes, it's a name, it identifies them. Is policy statement sufficient, e.g. individuals' names, ICO breach by account, do we say a personal file or all records? That's way too many bits of questions at the same time. Personal data is anything that identifies a natural person. Name, online identifier, IP address, they're all there. You need to have, if you're collecting personal data, a privacy notice that's covered in Articles 13 and 14 of GDPR. So it's quite a complex set of issues that you need to be dealing with. The concept that SMEs below 250 staff members wouldn't be subject to GDPR wasn't retained. That's correct. So all organizations are subject to GDPR. There is a derogation in GDPR that says organizations with less than 250 employees don't need to put in place the same level of documentation if there is no risk to the rights and freedoms of data subjects. To me, that's a kind of difficult issue to deal with. You need to be very clear that there is no risk to the rights and freedoms of data subjects before you put in place paperwork, and I would take some practical legal guidance on making sure that you're doing that correctly. You've got a retail shop with a fidelity program, therefore keeping customers' coordinates, invoicing on paper. Yes, you're advised to, yes, you have to comply with GDPR because you're processing personal data. It's in a structured filing system. Invoices are a structured filing system. I'm afraid, however you process data, you have to comply. Large scale is there is a working party definition of large scale and of core processing. It means high volumes in general, or it means a high volume in a specific context. So if there's only 1,000 people in a given universe, so 1,000 members of parliament, for instance, and you're processing data of 800 of them, I think that would be large scale processing. But typically it's tens of thousands of data subjects would be large scale. Your business is a processor processing data on behalf of controllers, generally controllers. Should we do a data protection impact assessment on our own behalf or preparation of the controllers who work for us? So that's slightly more complex than I suspect you're aware of. You're also a controller. You're a controller in respect of your own employees. You're a controller in respect of your relationships with councils because they're customers, and you collect and hold data of contacts at customers. So in all of those areas, you're a controller. In the areas where you are a processor, you need to make sure you have a contract from your controller customers with which you can comply. Yes, it makes sense for you to go and talk to them about what you think should be in the contract. You should be encouraging them to instruct you to carry out a data protection impact assessment because the obligation is theirs. The obligation is theirs where it's mandatory or necessary to ensure that a DPIA is carried out. I wouldn't necessarily carry one out on my own if I was a processor without the controller being committed to it and wanting it to happen. Is a signature on an internal company document classed as personal information? The question is, does the signature enable someone to be identified? If it does, then it's personal information. Do you need a DPIA for web applications? The same thing applies. A DPIA is mandatory where you're processing large volumes of data, and that large volume of processing is core to the business operations. So if your business depends on a web app and the web app processes large volumes of data, then yes, I think a DPIA will be mandatory. Where it's not mandatory, it might still be a good idea because GDPR requires you to demonstrate data protection by design and by default, and the only way you can design data protection is by doing a data protection impact assessment. Second question from a client: suppose we keep all customers' data, including on an external hard disk drive. What should we do should this HDD be stolen while on our way home? Well, you should feel very worried is the simple answer, because you quite clearly didn't apply appropriate controls to the HDD. It's got a whole bunch of personal data on it. I'm going to hope the HDD is encrypted, otherwise you've got an even bigger problem. Remember, you're supposed to be preserving confidentiality, integrity, and availability of data. The theft of the HDD means availability is compromised. If it's not encrypted, confidentiality and potentially integrity are compromised. You're going to have to report that. If you're a processor, you report it to your controller. The controller almost certainly will have to treat that as a breach which has a risk to rights and freedoms, and therefore will have to report it to the information controller. If you knew that a client had the same password for every email account in the business, what should we do as a practitioner IT support company? Resign would be one practical answer. It's obviously wrong. if it's the same password for every email account, then there is no security, there is no control over who has access to the information. It's evidently a high risk. I would say that if there was a breach, you would expect the investigation to lead to a conclusion that this was negligent, and the size of the fine would be based on that level of negligence. A client has been informed and advised they're at risk, but the authority to change the passwords has not been given. Well, the client is the controller. They have to make these decisions. They're at risk. You as a processor can make whatever decisions you think are appropriate. I'd take some legal advice on the issue. If controllers persist in having practices which are insecure, you would expect them, if they have to have a DPO, the DPO would be mandated to report that practice to the ICO. You might decide that you want to report it yourself. There's a number of different ways that you can deal with what is quite clearly a breach of GDPR requirements around security. Transmission of sensitive data, which is now called special categories of data, medical record, in email to a confirmed recipient using TLS, an appropriate method of securing in-transit data, or should be encrypted prior to transmission. You have to think about that. If you're going to put in a zip file with encryption and password security applied, how do you send the password? Typically that goes in an insecure format, which means somebody can get at it. But you need to look at the value of the data, the risk to the rights and freedoms of individuals, and determine an appropriate mechanism for dealing with it. More and more operating systems will make encryption available by default, and you want to be thinking about encryption of email by default, and you want to think about the extent to which you can use those kinds of mechanisms. If I get consent to keep in touch with a prospect, how long does consent last? It lasts as long as the purpose for which you collected the data. So if you say to the data subject, I'm going to get in contact with you until you tell me not to, and I'll get in contact with you every week, and the data subject consents, and they consent explicitly knowing that that's what you're going to do, then you can keep it for as long as you said you would. The period of consent the period of retention has to be related to the purpose of processing. We're kind of out of time, so I'll just answer a couple more questions. We haven't really got on to questions about risk assessment yet. Should risks be managed per data source, per business process, per category of personal data being processed? I would say you're going to manage risks. If it was me, I'd be managing risks on the basis of the data categories or data types in data inventories. I'd be looking at a data inventory like an HR database. I'd be looking at what types of data is in that HR database, and I'd be asking myself questions about vulnerabilities and threats that can exploit those vulnerabilities. GDPR does not dictate that businesses take on ISO 27001. They're not necessary for larger or smaller risk organizations. All GDPR says is that certifications to recognized international standards can be used by an organization to demonstrate that they've taken appropriate steps to meet their compliance organization. And final question, how does an organization's risk appetite interface with GDPR's requirements for risk assessment? Well, I think the interface is like this on that one of that final slides I was talking about. If you think that the organization is prepared to take big risks, that's fine. Where the organization is concerned, you have to think about what risks the data subjects are happy to take, which might mean you have to talk to them or their representatives. And so you might have a different risk appetite in respect of exposure to risk of data subjects than you have in relation to exposure of the organization to threat. And as we're over time, ladies and gentlemen, I'm afraid I'm going to draw us to an end. Thank you all for joining us today. I hope the webinar has been useful. We'll try and get these remaining questions, and there are quite a few of them, answered and made available over the course of the next couple of weeks as part of our broad database of FAQs. But I'd like to say thank you all for joining us today. There's an ongoing series of GDPR-related webinars. You can see more about those on our website, more information about specific aspects of GDPR. And for those of you who are coming to GDPR perhaps for the first time, and it might be that some of you on this webinar are, we're also running an ongoing series of first steps to GDPR compliance with touch in slightly more detail about all of the core areas like data breach reporting, lawful basis of processing, and so on. So those might be useful webinars for you. So thank you all for being with us. I hope that if you think we can provide you with useful information at a later date, you feel free to join us on a later webinar. Otherwise, I wish you all a very good afternoon. Thank you.